Ladies and gentlemen, here it is. The most listened to radio show on the planet. Even the other stations are tuned in too.
You're listening to In the Spotlight with Jill Nicolini on Business Talk Radio, where we take your business to the next level. Welcome back to Business Talk Radio. Mitchell A. Greebel joins us again today from Greebel & Greebel from Mineola, New York. He's an attorney, a full-service law firm he has there, and we want to welcome him back to the show. How are you doing today, Mitchell?
I'm doing great. Thank you for asking, Jill. By the way, Jill, before we get started, I just want to extend my condolences. I understand last week you were not here because of a loss of a family member, so I'm sorry to hear that with everything going around.
Thank you so much. Yeah, it was a difficult week to say the least, and around this time of Thanksgiving especially, so we've got to be thankful and grateful for it.
Exactly.
Thank you so much. I appreciate that, Mitchell. So please introduce
not
yourself
a problem.
to our listeners.
So just to recap, this is now the fourth show that we're doing. For those of you who are tuning in for the first time, I believe that my prior three shows are on the archives at Business Talk Radio, so you'll be able to go check them out. The first three meetings were the first one I dealt with the issue of divorce, the grounds for divorce, and whether the proper court would be family court or Supreme Court. 2 weeks ago, I dealt with custody, and last week I dealt with visitation, and today we're going to talk about child support. So I'm going to jump right in, if that's okay with you, Joe.
Let me just first introduce you with your website so people can find out how to contact you. It's Greeb. Is there a phone number you want to throw out there as well?
Absolutely, Jill. It's 516-248-7008, and I could be reached pretty much anytime you call that number. I could be found.
Perfect. Thank you so much. All right, so let's get started.
Okay, so child support is controlled and run by the state, and the concept behind child support is that it allows for the non-custodial parent, and we discussed a couple of weeks ago custody, non-custodial versus custodial. So the non-custodial parent is the parent who does not have the child or children primarily residing with them as a general rule, and they are required to pay a monthly amount to the custodial parent to enable that parent to take care of that child. And it's not more difficult than that. It's a basic concept. The fact is that New York State takes the issue of child support extremely seriously, and there are very, very, very strong mechanisms that have been put into place to enforce child support orders for the obvious reason. If a child support payment is late, then the custodial parent probably has problem paying rent or paying mortgages, paying for food, paying for utilities. And so the state takes a very, very serious look at the issue of non-compliance by a non-custodial parent. And the violations of those, which I'll talk a little bit further as we go along this, is very vexing. I mean, the consequences to what we affectionately call a deadbeat parent are draconian and are very extensive. And when clients come in and talk about them not paying.
Mitchell, stand by one second. We do have a caller coming in already. Stand by. Welcome to Business Talk Radio. You're live on the line with attorney Mitchell A. Greebel. Who's this?
This is Julia.
Hi, Leah. Ask any questions you may have, please.
Hi, yes. I'm calling because my husband and I own a business, and we're going through a divorce. I just want to know what are the steps I need to take to protect my share?
Certainly. So when you say you and your husband own a business, was this a business that was started during the marriage?
Yes.
Okay, and you each own 50% or a relative percentage of the ownership of that business?
Yes. We both each,
Okay.
we have both, yeah.
Okay, so you have your entitlement and your rights built in already with your ownership interest. And so your husband is not going to be able to sell the business or do anything negative to the business while the case is going on. The issue of who will be the last person standing, because it's usually unlikely that a divorced couple are able to continue to be in business together. I won't say it never happens, but it's difficult. So the issue really is which of the two of you want to be the last person standing, and what is the fair market value of that business to determine what the one who's going to be bought out is entitled to. So I'm not sure where you are at this point in your divorce action, but at some point, if that business is a viable business, the valuation of that business is going to come into play. And there's going to be a need for a professional to be appointed by the court to come up with a valuation. And then again, you and your husband through your attorneys will negotiate which of the two of you will be the buyer or the seller of that business. So during the pendency of the case, in theory, that business is protected by law. There's not, neither one of you could or should be doing anything to the detriment of the existence of that business. So you should be protected regarding that. If in fact there are problems with that, that's something you need to alert your attorney to, because there may be a need to petition the court to possibly remove your husband from ownership, from day-to-day operation, if in fact there are allegations that he's attempting to undermine the valuation. Absent that, it will be part of the marital pie that will ultimately be cut up between the two of you.
Okay.
Okay.
All right. Thank you.
You're welcome. You're welcome. So we're talking a little bit about child support. So in New York, we make it very simple for the attorneys. We do a very, very straight calculation based on the number of children the parties have. Simply one child, it's a 17% payment for child support, and I'll define what 17% of, what that means. 2 children is 25%, 3 children is 29%, 4 is 31%, and 5 or more is 35%. And in addition to paying that child support, you would also be asked to pay a portion, whether it be a pro rata or an equal division, of the unreimbursed medical expenses, which would be incurred on behalf of the children, and potential educational expenses. And when I say educational expenses, I'm not necessarily referring to a private school for elementary school. I'm talking about whether there be a need for tutors or supports for your children while they're attending school. Your child support does not cover that. That would be in addition to that amount. And so, as I said, it's very formulaic. We just take a calculator and we do the math. Having said that, there are deviations often from the child support calculations, and that will be based on a number of factors that the courts will look at, whether it be the financial resources of the parties, the financial resources of the child as well, which I can get into later, the physical and emotional health of the children and whether or not there's any special needs, the child's standard of living and tax consequences to the party, non-monetary contributions of the parties, the educational needs, and the needs of the non-custodial parents' other children in the event they have children from a prior marriage. So those are all factors in that are part of the consideration by the court before it directs what child support should be. The next question really is, how does one obtain child support? And there are any number of ways, 3 ways in particular, that a person can obtain child support. One is it could be ordered during the pendency of a divorce case. A party who's got the custody of the children can petition the court and ask for temporary support while the case is going on. That could happen in both the Supreme Court, which is one way, and in the family court, which, as I described in the first session with Jill, the family court are for those people who were never married. So in either one of those cases, a custodial parent can petition the court for child support. And the third way is, quite frankly, the most popular way and the easiest way for us to get everyone to a finish line, and that is if the parties involved actually agree to what the child support obligations are going to be. I would tell you that well over 90% of my cases end with a settlement as opposed to being forced to go to trial. So that's a good thing about this. That's a good part of this, that we do try to avoid trial, but it happens. And when it does, it's up to the judge to make a decision. And what we tell clients all the time, and a judge will tell this to the litigants, whether it be in family court or Supreme Court. They will say this to you all of the time. It is better for you to make your own deal than to let a stranger make the decisions for your life. And we tell that to our clients all the time. It is healthier for you to sit down at a table and negotiate a resolution of your financial obligations. Therefore, you have a potential of having some peace and détente and a happier existence after the fact. Because, Jill, as you could appreciate, if we have to go to trial, it's going to become more adversarial. There will be more animosity, and it will very often make it more difficult for the parties to get past that fight to do the right thing for their children. So we recommend all the time to try to figure out, if you can on your own, settle your case. And that's what we recommend highly, obviously, at all times. So what is child support for? What is it supposed to cover? And they're supposed to really cover the cost of raising a child. as I said, whether it be as a result of a mutual agreement between the parties or as a result of a court order, it's about the well-being of your children. And as I said, a party who is directed to pay support, who ignores that order, runs serious consequences, including criminal punishment as a result in terms of contempt. So very often, beyond the child support amount that we just talked about, we talked about the unreimbursed medical expenses. We also asked parents to be contributing to, as well as educational expenses. But there are other things that come into play, and it very much will depend on the case. There are certain aspects of cases, certainly on Long Island, where children seem to all be involved in extracurricular activities and very often go to summer camp. Those are other items which can be negotiated between the attorneys for their clients to decide whether or not they're going to participate in these extracurricular activities and whether or not they're going to participate in summer camp. I will tell you, Jill, that if at the time we are involved in the litigation, there is a history where children have been involved in extracurricular activities, or they've already attended sleepaway camp or day camps, or even in the situation where there may be a child old enough who's attending college, it becomes very difficult for the parents regarding the children who are younger, to say, I'm not going to pay for that, when it's well documented that you paid for that for your older children. And so you kind of create a precedent where it is expected that if you paid for Johnny to play lacrosse, you're going to pay for Susie to play lacrosse and maybe horseback riding and some other activity, because that's what that family did when they were, quote unquote, an intact, happily married couple. So those become consequences and become part of the pot as to what will be expected the non-custodial parent to chip in for. One of the other things that we deal with on this issue, which becomes a very big trade-off, is the issue of tax exemptions. Generally, we try to give the paying parent, the non-custodial parent who's paying support to the other parent, an opportunity to get some tax benefits and maybe take more, if not all, of the children as tax exemptions. So thereby they're getting the tax benefit of having the children on their tax return, but they're also the ones who are making all of the payments to the other spouse. The next issue that I wanted to touch on is the issue of enforcement, and this becomes the biggest issue with child support. Creating the agreement, creating the deal, getting to the two people to settle the case is a tantamount to a good deal. What we often find happening, and as Joe, you could appreciate in the era of COVID, we've got lots of people who are unfortunately facing dire financial consequences and are unable to meet their financial obligations and are seeking remedies from the court. As a general rule, if you don't make your payments for child support, you are subject to a number of consequences. Under the federal law, your tax return refunds, if you are in arrears and they are on notice of that through the court system, your tax arrears, your tax refunds will go to your spouse, your ex-spouse, to at least start to settle the arrears you have due.
Great. And excuse me at this time, Mitchell. I'm sorry, I have to interrupt you. We have a call coming in. Stand by. Yep. Welcome to Business Talk Radio. You're live on the line with Mitchell. Who's this?
Hi, this is Brittany.
Hi, Brittany. Ask any questions you may have.
Hey, what are my rights with joint custody during COVID? I don't want my kids leaving to go see my ex in North Carolina when they're in New York with me.
So that's a fantastic question, Brittany, and I have to tell you that it's a question that all of us matrimonial attorneys have been wrestling with the last 8 months. I have at least 2 cases going on right now where this became so heated between the parties. They have sought judges' intervention to try to get to an answer. The problem for us, Brittany, is that we don't have any case law to you definitively how the court would decide this type of situation. With joint custody, both of you have equal say, meaning one of you does not necessarily have a better say with regard to final decisions involving your children than the other. That being said, in the era of COVID, I'm hard-pressed to believe that if you express a reasonable explanation as to why You do not want your children presently to go to North Carolina. With the understanding with your ex that the time he's missing, we can talk about him making your date. I believe you are standing on solid ground, at least at this moment in time, because there are no cases telling us that, notwithstanding the COVID, children have to go to every visit that was agreed upon, obviously before the COVID became a reality. And so we, the legal profession, certainly in New York, I was part of a who was discussed. And the one thing I could tell you with absolution, there was no definitive response by the attorneys on that conference call. There were no answers at this point because we don't have any guidance. But I would say to you, I'm hard-pressed to believe that you would be in the wrong for doing what you think you need to do to protect your children, especially when you're talking about traveling through many state lines to get to visit their father. And again, it's not about him not seeing the children. It's about them not seeing him right now. And I believe that you would have the ability to make that as a defense. Having said all that, Brittany, I would advise you to go back to your attorney who represented you in the divorce and have some conversation with him as the best way to dot your I's and cross your T's, because you can probably anticipate at some point your ex-husband may make this a scene or an issue in the court system as well. So as long as you can demonstrate that you've done everything you can to protect those children, I believe you will be in a good place if this becomes a court case.
Right. All right. That's great. I appreciate that.
Great.
No problem. I
Thank
wish
you for the
you a lot of luck.
And good luck. And at
Thank
this
you
time
so
of the
much.
show is where we take our commercial break. Mitchell, give us the best form and all forms of contact for you, please.
Sure. So it's Greebel and Greebel. We're located in Mineola. My office number is 516-248-7008. As Joe mentioned, my website is www.greebelgreebel.com. Please feel free to reach out to me for assistance in any divorce or related matter. Thank you.
Beautiful. Thank you. Stand by. We have more after the break. And don't forget 631-627-1840. If anyone else has any more questions for him, please feel free to call in. We'll connect you right away.
Feeling anxious or depressed? Struggling with an event from the past? Do you feel like you're not achieving your full potential? Do you need closure or answers from your deceased loved ones? Soar to new heights with Angel Wings and Healing Things. We have the tools to get your mental, physical, spiritual, and emotional well-being back on track. With a variety of services including hypnosis, essential oils, sound therapy, cranial sacral, energy work, mediumship, and more, there's an option for just about everyone. Take the step and become your happiest self. Visit angelwingsandhealingthings.com. Send an email to awnht@comcast.net or call 704-562-3476 to start your journey. Because remember, you are worth it. Do you want better health with natural solutions that work? East Wind Acupuncture, a 20-year traditional Chinese medicine clinic in Chesterton, Indiana, does just that, offering acupuncture, herbs, massage therapy, and nutritional support. East Wind has helped thousands of people eliminate symptoms and regain health. They offer a comprehensive health review, Chinese medical exam including tongue and pulse diagnosis, and customized treatments designed for optimum results. They also offer educational programs, lifestyle classes, and workshops. For more information or to schedule your free health consultation, visit the website ewacupuncture.com or call 219-395-9928. East Wind Acupuncture, restoring health naturally.
Do you think you could share a free ebook called Viral Attraction Marketing Secrets? If you had proof, it would build an active team under you before you had to pay to join a great company? I'm Christy Sales, offering you the chance to see this system works. Download your free ebook now at iCanMakeCash.com. We have high demand products and a spotless reputation for paying every week. iCanMakeCash.com.
Ladies and gentlemen, here it is. The most listened to radio show on the planet. Even the other stations are tuned in too.
You're listening to In the Spotlight with Jill Nicolini on Business Talk Radio, where we take your business to the next level. Welcome back to Business Talk Radio. We are joined once again here by Mitchell Greebel. He's an attorney, and we're talking today in regards to child support. Again, one of the specialties that he specializes in. He's based out of Mineola, New York, here on Long Island. I want to welcome you back to the show, Mitchell.
Thank you, Jill. Thank you. So I was
continue,
just getting into the issue of child support enforcement. So one of the mechanisms that are available to a custodial parent who isn't receiving the money they're supposed to is to serve the employer of the non-custodial parent with what's called a wage garnishment, which would result in the automatic disbursement of the money from the non-custodial parent to the parent. That works when the non-custodial parent works for a third party. When the non-custodial parent works for him or herself, a wage garnishment is going to be obviously a waste of time, because if they're not paying the money, they're certainly now not going to pay it just because you served it upon them as employers. So the remedies available for failure to pay are, as I stated, pretty draconian. In addition to the ability to take tax refunds from the non-custodial parent and give that to the custodial parent for the arrears that have accrued, there is also the possibility and strong likelihood that the non-paying non-custodial parent could be facing incarceration under contempt. Now, even with the COVID going on and with bail reform occurring, I will tell you that the judges, certainly in Nassau County, are sending deadbeats to jail as we speak, as I had a case recently that only because the person came up with the money at the last moment, they otherwise were going to jail for 45 days. The fact is that, as I said, the state takes the failure to pay very seriously. If you are able to demonstrate to the court that the failure to pay was willful, meaning that person could have paid and chose not to, they are facing dire consequences. In addition to a possibility of incarceration, they could lose their driver's license. If they have professional licenses, those professional licenses can even be suspended. So the issue of paying your child support is taken extremely seriously by the court. And as I say to clients who come in and have not made their payments, that the first thing we need to do is apply immediately for what's called a modification, a downward modification, which I will touch on as we continue, and at least seek a reduction in your obligation so the court does not perceive your failure to pay as a willful, contemptible action. And so the next topic that I'm just going to jump on is the issue of child support modification. So you sign an agreement, and years later you're getting the same amount or you're paying the same amount, and things change. Things become more expensive, life changes. The law actually allows for, after a child support has been fixed, whether it be by a court or by the parties, to be modified if you're able to demonstrate that there has been a substantial change in circumstance. Now, there's no hard and fast rule with that, Jill. It's going to be a case-by-case study. The court's going to look at your facts and determine whether or not your change, your substantial change, was the sort that would entitle you to get a downward modification. For example, a person deciding to no longer go to work and decides at one point after making $200,000 a year, they wanted to become a short order cook and make $40,000 a year. The court felt that that was not a substantial change of circumstance. In fact, that was a self-motivated one for which they were not going to award that person, and there was no modification to the child support order. In addition to a party seeking a modification, and keep in mind, that modification can go in either direction. A husband or wife who's paying support who now have lost their job and have demonstrated to the court that they have exhaustively looked for a replacement job and have been unable to find one are likely to receive some sort of downward modification, some sort of relief to help them with that situation.
And welcome to Business Talk Radio. You're live on the line with Mitchell. Who's this?
Hello, my name is Nick.
Hi, Nick.
How are you?
Good. Ask me any questions you may have.
I was wondering, I'm driving here on the road, and I was wondering, how long do you have to be separated for before I can be legally, divorced?
That's a fair question. It was a topic I discussed at our first session, Jill. The issue of being separated is no longer significant in New York State. If you can demonstrate and say out loud that you have an irretrievable breakdown of your marital relationship for at least 6 months, you have grounds for a divorce. You do not need to be separated. You have the ability to file papers today and seek a divorce. There was a time before we adopted what we call no fault, and we call it the irretrievable breakdown of a relationship. That's how New York defines no fault divorce. Prior to that, we needed something like separation for at least a year before you can claim grounds for abandonment. We don't need to do that anymore with the availability of the irretrievable breakdown in a marital relationship. So I'm going to suggest to you that you probably don't need what you think you need, and you probably can, as we speak today, commence an action for divorce.
I think I can, actually. Thank you. That really cleared a lot of things up for me.
I wish you luck.
Thank you. You guys have a great day.
You too. You too.
Thank you. Have a good day. And go ahead. You can continue. We have just a few minutes left, 2 minutes left to be exact. So we'll kind of sum it up.
Fair enough. So I just wanted to touch on, in addition to that substantial change of circumstance, which is, as I said, could be by either side seeking an upward or a downward, depending on what that change is. The statute we passed in 2010 provides that if there have been 3 years since the order was entered or last modified or adjusted, the court can look at it to determine whether or not there has been a modification, okay? If there's been a change in either party's gross income by 15% or more since the last time a child support order was entered, you would have a right to a modification as well. And so there are basis for modification built into the statute based on just life itself. 3 years passing, a 15% increase or decrease, one has the right at that point to seek a change with a change of circumstance. A person at that point has the absolute right to seek a modification to their existing obligation, and it's retroactive to the date of application. And so we often make an application, let's say we bring it on December 1st, and the court does not decide it for a variety of reasons till May of next year. It's retroactive till December, so to the extent you may have underpaid or overpaid, the court's decision will provide for a way to make up either the shortfall or how you will get credit for the fact that you possibly overpaid for the last 5 or 6 months. So there are mechanisms to change your child support obligation. It's all a case-by-case basis. It's all based on the facts of the case. And as I said, if you in fact are in a situation where you're paying more than you believe you could afford, I would suggest now is the time to speak to an attorney to see whether or not there can be any downward modifications for your obligation. And conversely, if a person is sitting at home now and is not really making it with the amount of child support being made, and there's a belief possibly that the party who's paying you that child support potentially is making more money, that is an avenue that you should as well be investigating and determining whether it's in your best interest at this time to make an application for an upward modification.
Right. Well, thank you so much for your time today. And one more time, give us your website, please, Mitchell.
Yep, it's www.greebel.com. I do have a Facebook page under Greebel and Greebel as well, and my telephone number is 516-248-7008. Again, it's 516-248-7008. Jill, thank you once again.
Thank you.
Have yourself a great week.
You too.
Ladies and gentlemen, here it is, the most listened to radio show on the planet. Even the other stations are tuned in too.
You're listening to In the Spotlight with Jill Nicolini on Business Talk Radio, where we take your business to the next level.
This is you over 30 years ago.
Are we there yet? Are we there yet?
And this is your mom when you drive her back from therapy.
Are we there yet? Are we there yet? Are we there yet?
Roles change without us noticing, and in your new role, we help you help. AARP gives you the information to help care for your mom so that you can have patience with her just like she did with you. Visit aarp.org/caregiving or call 1-877-333-5885 to get practical health and wellness tips to provide even better care for your loved one.
Are we there yet?
Remember, visit aarp.org/caregiving. AARP, we help you help. A public service announcement brought to you by AARP and the Ad Council, by AARP and the Ad Council, by AARP and the Ad Council, by AARP and the